So, quick introduction: Josh Pierson, ACLU of Kansas, senior staff attorney, is here with us. So we're just going to go over the ACLU Kansas has written a letter to the city of Blue Rapids compelling them to cease prosecution of David Sang for displaying a flag that said "fuck Biden." Although we're not representing Mr. Sang at this time, the letter made clear our concern for First Amendment violations and are wrapped in city's action. So Josh is here with us. He's going to go. I just love maybe Josh to give a little bit more background on the case or how we got involved with it.
Sure. And yeah, just one sort of quick development, I suppose. So we actually do represent David Sane now. Since we sent the letter asking the city to drop the prosecution, they have refused. So we entered our appearance, and I appeared in Blue Rapids Municipal Court about a week ago, and appeared with the judge and on the case, and it looks like we'll be. That the city plans to move forward, which means we'll be planning to move to dismiss.
Oh, wow. Yeah, cool. That is a big development then. Cool.
Yeah.
So you're already catching this way up. So I'd love to hear more about the background, though, of how this all came together then.
Sure. I mean, so we were first contacted not by Mr. Sane, but by the media. So KSNT in Topeka reached out to Mark McCormick, actually, our communications director, and asked if we had a comment on this situation. And so that's how we first learned about it. Mr. Sane then contacted us himself individually, and we got involved. It's a very, in some ways, just simple, straightforward, and almost academic application of the First Amendment. It seems quite clear that this kind of prosecution isn't legitimate. So.
Sure. Yeah. Well, I think too that now that you're rehashing a little bit, did we get contacted by a news station in New Jersey too, or something like that? Is this a wider spread? I don't know if that's a super unfair thing to just throw at you. I don't know if you have any inclination on that.
Yeah. So I don't believe we were contacted by a news station in New Jersey, but what was the case is that there recently, within the last, I think it was this year, there was a nearly identical flag. It might have actually been the exact same flag. That a city in New Jersey was charging one of its homeowners for flying, and the ACLU of New Jersey got involved there, sent a similar kind of letter that we have sent, and there was, I forget exactly the procedure in New Jersey. I believe the homeowner had already been convicted of the violation, but it was on some kind of appeal, and then when the ACLU got involved, the city dropped the appeal and dismissed. So.
Gotcha. So yeah, I appreciate that background too. So in this instance, I'm sure the city I'm citing an obscenity law, or I don't know if they have some sort of statute in place that they're trying to stand on. Can you give us a little bit like maybe the legal background or what your considerations are when you look at this?
Yeah, sure. So the ordinance that they have charged Mr. Sane under is an anti-obscenity ordinance. It's actually this. So he's been formally charged with promoting obscenity as the charge.
Okay.
It's a model ordinance that this organization creates and writes that gets adopted by municipalities all over the state of Kansas. So the ordinance itself is not novel. It's not particularly contentious or unusual. What's unusual is the way that it's being used here. So it really, even on its face, but certainly to be constitutionally permissible, the ordinance really only applies to what are legal obscenities, which really refers not to curse words and swear words, but more, the courts say, prurient interests. Things like sex shops and porn shops, and typically it involves some sort of sexual aspect. And that's the thing that the courts have said is not protected by the First Amendment. It's the reason ordinances like that are passed and are allowed to exist.
And the most explicit pieces of that, right? Just you can't explicitly show those types of images, I presume, right?
Yeah, I mean, that's generally the case. Although even there, I mean, especially, often you see these phrases like with no redeeming value, no political content, I mean, so it's not quite like, oh, if it's sexual, it can't there's no First Amendment protections. But in general, yeah, I mean, so obscene speech is sort of a category of lower First Amendment protections. But by obscene, the courts mean prurient, sexual, erotic, something like that. So
not the F word is what you're
not the
saying.
F word, exactly.
Yeah.
So I mean, right. And so I think in fact, one of the things we pointed out in our letter is that this ordinance probably doesn't even apply. Like, forget the First Amendment. This isn't even a violation of the ordinance, you know? And so an interesting take the city has made.
Nonetheless, they're so is it protected? Well, so first of all, I mean, you kind of threw me off, because if it's not protected, a violation of the ordinance itself, then it's hard to even like clarify that, because it's non-pursuant. But let's say that the ordinance did include curse words in there. Would the ordinance itself then be unconstitutional? Can you forbid curse words, or would it, or I guess, is it protected because it's political speech in reference to the president, or what? Where do the lines get drawn on that typically?
Yeah, I mean, so it can become pretty fact intensive pretty quick. And it's sort of like I would need
Every
to
lawyer's favorite thing too, right? Just make it really specific and
right.
hypotheticals, right?
And it would sort of, but yeah, there would potentially be a different analysis depending on, each of the sort of examples. But I would say in general, some ordinance that just forbid the use of curse words, I don't know, that seems problematic to me. But then at the same time, I don't know, it would be sort of content neutral in a way if it was just sort of no curse words. I don't really know. The fact that Mr. Sain's political speech is certainly, the fact that the flag, Mr. Sain's flag, is political speech is certainly a relevant. It's a relevant consideration, right? It's like this kind of thing is exactly what the First Amendment is designed to protect. And our elected officials shouldn't be the ones policing what people say about elected officials, right? I mean, so because it is political in nature, it certainly is of a higher order under the First Amendment. Though even then, I'm not positive that's the only reason it's a violation here. So yeah, I mean, I think it would depend in general. The other thing I'll say is, the courts and the First Amendment jurisprudence allows for reasonable time, place, and manner restrictions on speech. As long as there are other ways or other avenues for people to make comment or to speak. But that isn't what's going on here. This isn't some reasonable time, place, manner restriction. This is just because it has the F word in it. We don't want you to put it up, and so that's pretty problematic under the First Amendment.
Yeah, well, that's super interesting. I recognize how obnoxious it is sometimes to throw hypotheticals at lawyers, but I also want to acknowledge how fun it is to do. So I just so I will hold myself back a little bit, but it's
that's all right. Go
fascinating.
Go wild.
I'll ask you just maybe a brief history of First Amendment issues, and especially as they relate to this case. I know our letter had a handful of previous cases, a lot of Supreme Court cases cited. I just thought maybe you could give us a brief overview of some of those considerations.
Yeah, sure. So I think really the controlling case here, the big lead case here, is California versus Cohen, which is a case from the 70s, the early 70s, and it was about a Vietnam War protester. And the defendant in that case wore a jacket to LA County Court that said "fuck the draft," and was ultimately charged under a version of an obscenity ordinance there. And the Supreme Court, it's kind of an interesting opinion, because it sort of begins by saying, well, you might wonder why we're taking up something so minor, and then it goes into this whole thing about how that this is what the First Amendment is designed to protect. The fact that it might be offensive isn't a reason to limit it. The fact that it might use a word some people find crude or whatever, that's not a reason to prohibit people's speech, and especially on content like that, on a political statement. So it's funny in some ways. It shows how nonpartisan or sort of non-issue specific this right can be, right? I mean, so
right.
Some people might might see a difference between fuck Biden and fuck the draft, and yet the same right is what protects both speech,
Sure.
both pieces of speech.
Sure. That's such a good point too. That it's foundational. Which I guess brings me to another quick question for you of like, because this is so First Amendment, so is this something that can vary from state to state in significant ways, or is this pretty universally across the country seen the same way? Would you think?
Yeah, I mean, so so this is federal law that governs this action and this issue. There, and if that's actually a good point. There might be some interesting Kansas law on it. Many states have a version of the First Amendment in their own constitutions, which could potentially vary from state to state. But this is federal law. This is the First Amendment. It's the Bill of Rights. It applies this way across the nation, no matter where or who you are. So
Yeah, and so there's no that makes sense. That's why I know that everything with law too varies so much state to state that
yeah.
it felt worth clarifying a little bit more. So zooming out a little bit more too on First Amendment rights. So like, what type of restrictions come to mind in terms of First Amendment speech? Where might you find more restrictions rather than the instance that we're seeing here in Blue Rapids?
Yeah, I mean, well, so like in other words, where would it be permissible? Is that what you mean? Or
I suppose. I mean, I guess what I'm saying is like I was hoping we could zoom past the famous is like you can't yell fire into a crowded movie theater, right? Is like, oh yeah, there's restrictions on free speech, but and I think you covered it really well with the Cone case, right in California, that just using the F word is not itself permissible, but I guess just generally, I feel like we're in an interesting spot, not necessarily First Amendment right wise, or in some cases, but just like the limitations or the considerations against different groups of speech. Are there considerations, or are there ordinances that a city could implement that might be upheld differently than what we're seeing here?
yeah, I mean, so we mentioned obscenity as sort of a category of lesser protected speech. There are other categories. Fighting words is the good example. I mean, so speech that incites violence is less protected under the First Amendment, maybe not protected at all, depending on the circumstances. And so that would be an example of something that the government could rightly, or at least constitutionally, regulate. The other place you see it sort of, we mentioned time, place, and manner restrictions. I mean, so you see it all the time with like ordinance or with like permit requirements. I mean, like in general, that's a permissible restriction on speech. Like if you get a permit to go
To demonstrate.
to demonstrate or something that depending on the circumstances could be upheld. And then there are other considerations there too. Courts will often look to the place itself. In other words, is it a historically open place where people did gather and assemble and potentially use their freedom of speech? And so like the streets are often the example given, that like the right to march through the streets is a historic and well established, time honored place to express for political expression and association. And so where and how the government attempts to regulate speech can depend on that. And then the big thing is sort of, the government shouldn't be in the business of picking and choosing the kind of speech it likes.
Right.
And using its power to prohibit certain kinds of speech, but not others. And so that can become very important as well.
That's what I was going to ask you. I know that there are some instances of contention, but do you know much in terms of, this is another super unfair question I'm just throwing at you, but have you, I know that you haven't, well, whatever, have you worked or are you aware of many instances where the government maybe unduly or was seen as unduly restricting permits, or I mean, is that relatively common at all?
Well, I mean, that certainly it can be an issue. I don't know if like
Super unfair. I know, yeah.
No, it's okay. I mean, and I know our affiliate, even I think it was maybe last year, there was a letter of warning that we sent to the Overland Park Police for their conduct in policing Black Lives Matter groups that were protesting or marching. And so there, that kind of thing can be an issue, certainly.
Yeah. That's, I just think, yeah, it's so so interesting, and And like this case, like you said, is just seems like a really good demonstration of the importance of retaining those rights, and the fact that the government being in the business of regulating is specifically what we're trying to avoid. I'd love to ask you a little bit more, just kind of a wrap up question here of, especially now that I know that we are representing Mr. Sane in this, what are the kind of the next steps? What should people be looking out for in terms of this case?
Yeah, so we will appear the next time in court next month. We there's a it sounds like the city may be amending the charges and potentially bringing different or more charges against Mr. Sane. So if they do that,
Make your job more interesting. Just make sure you keep you on your toes.
Right, exactly. If they do that, we'll need to analyze those charges, but my guess is it doesn't really change much. And then so once we know the charges that the city has decided to pursue, then we will be in a position to brief and file a motion to dismiss, essentially asking the court to order that the First Amendment applies and that the prosecution is illegitimate. We still remain hopeful that the city will be persuaded by our letter and by the law, and we'll look at it and realize that this is an inappropriate application of their ordinance. And so if that were to happen, we'd welcome it. But anyway, and then, depending on what happens next, if the court were to agree with us and grant our motion to dismiss, it would be over, at least at this court. If the court disagreed with us, then there would actually be there would potentially be a trial. I guess I don't know. But because it's a little funky because it's municipal court. So since it's a municipal violation, it's a municipal court. It's actually a city of Blue Rapids municipal court. But Mr. Sane and all of us, he has a right to then appeal de novo anew to the circuit court in the county in which he lives and have an actual district court, trial judge in the state of Kansas look at the issue. And then from there, we could keep going on up. So it depends sort of on the city's appetite for how much they want to pursue this, So.
Sure. So just real quick too, to clarify, maybe a little housekeeping for myself, because I think I kind of spent past this. So as it stands right now, the charges that are brought against him, is it a pretty modest fine? What would be the outcome if he weren't to appeal it at all?
Yeah, so it's potentially a very large fine, and it's something actually that I need to get more clarity around, but it looks like it could actually be as high as a $50,000 fine.
Oh, wow.
And so it's like no small thing,
Yeah, that's not necessarily what I expected the answer to be. So that, it seems to only add, I'm sorry.
No, go ahead.
I was just saying adds to the imperative of, I think we're probably, by virtue of our occupations, into the idea of pursuing freedoms and First Amendment rights for their own sake, but also to avoid, $50,000 and so those sorts of penalties associated with it seems to only increase the imperative to do that.
Yeah, and I should just to issue a disclaimer. So this is, it's obviously I've never defended a municipal prosecution in Blue Rapids before. There's a chance that $50,000 fine would only apply if it was a repeat violation.
Sure.
And so maybe arguably that wouldn't be the case here since it's the first prosecution. So it may not be that severe, but it does show you how quickly and how seriously.
Yeah, fines up to. Yeah, that's an appropriate disclaimer, and I appreciate that. But yeah, that I think adds to the layers there. So I want to make sure I have one last question I would like to throw out of just like I like to call it the I'm an idiot question of just like, what did I miss? What's and or the nerd out question of like, what's maybe not even like important, but super interesting that we didn't cover? Is there anything that we need to make sure we cover our tracks on?
Yeah, I don't know. No, you did a great job. These are great questions. I would point out and just sort of emphasize that like this right in many ways, and it gets described this way ad nauseum, but this right is foundational, and the same ordinance could be levied at a Black Lives Matter sign or at fuck Trump, it's just, you could just literally change one
whomever, right? Yeah,
right. And it really is, the interest of everybody isn't necessarily obviously isn't in agreeing with Mr. Sane or his message, but in what powers do we want the government to have? What powers do they in fact have? And limiting the government's ability, limiting elected officials' abilities to regulate what people say is a good thing. The other thing I'd point out too, that we didn't really touch on, is besides just the ordinance itself and the unconstitutionality of the prosecution, there's a really bizarre and troubling way that the prosecution came about in the first place, which is that there was apparently like a citizen petition of some kind that the mayor received. We think it was the mayor, and it was only after that petition that they brought the charges. In other words, had been flying his flag for a number of months, as I understand it, before he was charged with the violation. It was only in response to the citizen petition. And while in general, I'm in sort of in favor of like democratic citizen,
allowing citizens to petition or raise
right,
issues.
we should all be a little troubled about the idea that our neighbors could just get together and get the city to prosecute us for something they don't like. And so that's a real problem with the way that this happened. So
Well, that it also, I think, speaks to like the idea too that they were able to find, or maybe not, as you kind of pointed out, but that there was a relevant law. Once it was brought to them, it seemed like they had the arsenal of like, oh, we have an obscenity law, we can just use that or whatever. So that is interesting. Timeline there. So awesome. Josh Pierson, Senior Staff Attorney with ACLU of Kansas. Thanks so much for joining me. If you want to follow along on the case, I encourage you, and I'm very biased in this matter, to follow along on social media. I'm talking to the audience and not you. I'm hoping that there will be an audience. Thanks a lot, Josh.
Thanks, Jeff.